Dear participants, a very warm welcome to this webinar. I'm Professor Pascal Pichonnat from the University of Fribourg in Switzerland, and as president of the European Law Institute, it is my great pleasure and privilege to welcome you all to this webinar. In February 24, ELI membership has approved the so-called ELI Charter of Fundamental Constitutional Principles of European Democracy. A fantastic project and endeavor to set out the fundamental constitutional principles of a European democracy. We at ELI think that this project is timely and will become of great importance as a milestone, given also the current and ever-changing political situation in Europe and around. For those of you who attended already the previous webinar on the topic, you know that the ELI decided to organize a series of webinars to discuss the various parts of such ELI Charter of Fundamental Constitutional Principles. As the project consists of 7 parts, we decided to organize 7 webinars on each single part. The first webinar on liberal democracy took place on 11th March, and the recording is available on ELI website. Today's webinar will deal with the second part, the rule of law, principles 7 to 13. As we've done with other projects, each chapter is broken into principles, and each principle is accompanied by a succinct commentary on its intended meaning and scope. The reporters have also provided an indicative list of references to legal sources. The 2 reporters, Professor Elise Muir and Professor Takis Tridimas, have achieved an incredible work under the chairmanship of Sir Francis Jeffrey Jacobs, first president of the ELI, and Sir Geoffrey Joel, KC, who is with us also today. This project has been presented and discussed several times by the scientific director, Professor Christiane van der Horst, and by the executive committee, as well as by the ELI Council. Moreover, the project or part of it have been presented at several occasions at ELI annual conferences, but also at high-level conferences on constitutional law in Europe and beyond. The final outcome is therefore the result of the individual work of the co-reporters, but benefited also a lot from collective thinking and interactions. There will be further bi-weekly webinars, as I said, to discuss other parts of the Charter, and more information will also be shortly provided in the chat. As always, you will be able to ask your questions thanks to the Q&A function, and we will answer those questions in the Q&A session after the first round of interventions by the panelists. Today, we have the pleasure to have one of the co-chair of the project, Elise Muir, co-chair, sorry, Professor Sir Geoffrey Joel, KC, as well as a co-chair of co-reporter of the project, Elise Muir. Let me just say a couple of words on Professor Sir Geoffrey Joel. He's a practicing barrister in London and Professor Emeritus of Public Law at University College London. He was the inaugural director of the Bingham Center for the Rule of Law from 2010 to 2015, and the UK's member of the Venice Commission, the Council of Europe's Commission for Democracy Through Law from 20 to 2012, where he chaired that body's committee which produced their document on the rule of law. And Elise Muir is professor of EU law at KU Leuven. She has a particular interest in EU constitutional and fundamental rights, as illustrated by her 2 monographs in the field, published in 2012 and 18 by Kluwer and OUP. She's the principal investigator of the so-called Reshuffle project, which deals with the transformation of the institutional landscape for the protection of fundamental rights in Europe. She has recently published a handbook on an introduction to the EU legal order. And I think that's a nice introduction to give you directly the floor. Elise, you have the floor to present this second chapter of this charter. Thank you.
Thank you so much for this introduction, Professor Pinochaz. It's a great pleasure, it's a great honor to be here today to present the work we've done together with the chairs. You have introduced them, Sir Francis Jacobs and Sir Geoffrey Jorwell, and the co-reporter, Professor Takis Tridimas. I thought by way of introduction, I would say a few general words maybe on the origin of the project. As you have said, we believe that this is a very timely project in a context in which the fundamentals of constitutional liberal democracies are coming under pressure. So we were asked by the ELI, by the European Law Institute, to reflect on the common features of European constitutional principles in order to be able to reassert these principles, to make a public statement across Europe and possibly the world, if there would be interest. The nature of the Charter is largely, I would describe it as a sort of an academic exercise. You have described very well the process, a very deliberative process, and I think that Takis Tridimas and myself would really insist on this. We have received a lot of input and exchanged a lot with a wide range of actors. In terms of the sources we've used to come to these common principles, we've been looking at official documents, constitutions across Europe, but also constitutions outside of Europe, case law from highest courts, but also academic contributions. And as you have said very fairly, I think, and aptly, these are just these are a non-exhaustive list of sources. So we provide some commentary on each principle to explain a little bit where the ideas came from. So a broad range of sources, primarily of European origin, but in fact with some resonance and some inspirations drawn from other systems. And Professor Kim Schreppele, who is here, has also, for example, brought a lot of input on elements from US experiences, just to give an example. Perhaps I should add that the Charter is not meant to be a constitution. It is just a text that proposes and puts forward some horizontal features which we believe are shared across European legal systems. We have been looking for we've been searching for a balance. We hope we struck the right balance between a descriptive approach and a prescriptive approach. It is challenging to try to identify some common features. We have tried to rely on existing developments, but on a number of occasions, we also have been making decisions on where we think the line should be drawn between the acceptable or the unacceptable and what could be used as guidance for the future. So with these very general comments in mind, perhaps I can just briefly share just a quick overview of the structure of the Charter, as you can now see it on your screens, and I hope that this is working. The Charter is composed of 7 parts. 1 on liberal democracy, 1 on the rule of law, 1 on judicial independence, 1 on checks and balances and accountability, 1 on dignity and equality, 1 on the protection of fundamental rights, and 1 on constitutional integrity. As Professor Pichon has said, each of those will be the subject of a webinar. What I can say already, though, on this list is that it is not exhaustive in the sense that this project is, in a way, inherently imperfect. No, I mean, we try to picture some general trends and general features, and we know in a way that there will be need to revise this Charter. So we acknowledge this in the preamble, in the introductory statements. This is an ongoing exercise of reflection and deliberation to which, in fact, this webinar participates. So we will continue to engage on the basis of these principles in the future. What I also wanted to add by way of general comments is that in these principles, we also include some principles that one would not obviously find in a constitution. So sometimes we've been a little bit creative. For example, with a principle on the protection against disinformation, which is number 6, or a principle on automated decision-making, which is principle 32. Because we have wanted to, and with the support of ELI, after exchanging with the various instances of ELI, we have wanted to put forward a text that addresses some contemporary challenges to constitutional democracies. Now, the project, or the part of the project we want to discuss with you today more specifically, is part 2 on the rule of law. Part 2 is composed of 7 principles, which you now see appearing on the screen. And the idea across the charter is that each principle is stated in a few lines, 1 to 10, and that below the principle, one can find a commentary of, half a page to 3-4 pages. The commentary is meant to shed light on the sources we've been using and to explain our reasoning, or what allowed us to lead to the conclusion that there was a principle in this field to be formulated in the way we suggest. So the 7 principles, perhaps I can just briefly say a word about each of them. If you are interested in the discussion, I can put them on the screen. I have them on the slides, but I think it's a bit too heavy for just this short presentation to read through them all. Rather, I'll just say a word about each of them. So the rule of law, the idea is that the rule of law requires public and private power to be exercised in accordance with the law. The idea very much is to state that the government and public authorities in general, in fact, even private public authorities, to the extent that they may shape the public sphere, may not act arbitrarily. So this is really a statement against arbitrariness. The principle of legality participates to this logic, in that it is meant to require that public power is exercised within the boundaries of the law, for example, in a transparent manner, with decisions being reasoned, so that people can know which rules have been complied with and are being implemented. The third principle is the principle of legality, which appears at number 9 in the charter. And here our concern was to assert the importance of foreseeability, clarity, predictability, accessibility, and the fact that rules should be binding for the future in principle. It doesn't mean that exceptions are not possible, but it means as a general rule. The right to a fair trial is principle number 10. You may notice, if you go through the charter, that we also elaborate further on the notion of judicial independence in part 3 of the charter, but we felt it was important to assert a right to effective judicial protection as part of the principles governing the rule of law. The principle of proportionality, the idea that public action must be appropriate and necessary. Respect for international law, this is something we discussed a lot in the group, but we felt it had to be asserted. The rule of law does not stop within the legal system at the Constitution. It also includes due respect for international commitments made by the state. And a statement on the review of constitutionality in principle 13, the idea being that even if there may be different ways of doing this, there should be ways, at least in every legal system, to ensure that there can be a check on the compatibility of state measures with higher levels of norms, fundamental constitutional principles. So I hope that with this very short introduction, I have been able to explain our approach and the history of this project, of this charter, and give you a bit more information on the rule of law. And I'd be very pleased to give the floor to the chair, the co-chair of this project, Sir Geoffrey Joel, in case he would like to share with you some further thoughts. And I look forward to the discussion.
Thank you. Thank you very much, Elise. Can you all hear me? Good. Thank you for that introduction. I'd just like to go back a little bit because the chair mentioned that I was involved in the drafting, in fact, the chair of the committee that drafted the Venice Commission's 2 documents on the rule of law. We began about 15 years ago. And there was very little, and I think this is interesting, there was very little consensus at that point, even in a country that espouses the rule of law, or claims to, such as the United Kingdom, as to what is meant by the rule of law. For some, it was a very legalistic concept. You must obey the law, what we sometimes now call rule by law, whether the law is put forward by the party or by a democratic system. And for others, it was a very vague concept, a contested concept. And then there were those who said, well, there's the rule of law and there's the état de droit and there's the Rechtsstaat, the concept of Rechtsstaat, and they are all different. And one of the most interesting exercises that I've ever engaged in on an academic and quite a practical level as well was forging consensus among very different systems about what we meant by the rule of law and whether these were universal values in any certainly in any democracy. And we were helped at the time by a book that came out by a very famous British judge, Tom Bingham, called The Rule of Law, where he put forward the notion that the rule of law we can define it in a short way, but ultimately it consists of different ingredients, as he called them, different principles, as we here call them, that all hang together. They are separate principles, but they all hang together as part of the rule of law. And I think that's very important in understanding the rule of law, to understand that it has different features which together form what we call the rule of law. And very briefly, to sum them up, they are legality. And Elise has mentioned the notion of legality. We all obey the law, but the government must obey the law as well. And the adoption of the law must be transparent and accountable in the democratic process. And that raises the question of what about discretion? Is that part? Does it have to be a rule, or can there be something more flexible in the way of discretion? Yes, of course, but short of arbitrariness. So arbitrariness, as Elise said, is not compatible with the rule of law, and therefore reasons are required. And that is contained in under Principle 8, under the principle of legality. Yes, legality, yes, obeying the law, but looking deeper into it, it allows for discretionary powers so long as they're controlled, and reasons must be provided for decisions to avoid arbitrariness. And that was very much also part of the Venice Commission's a paper on the rule of law, concept of the rule of law. The second feature of it, and that's contained here under Principle 9, is legal certainty. Obviously, law can be changed, but it must be changed with fair warning, and it must be clear and predictable so that those to whom it applies are in a position to understand what their rights and obligations are. And there's also, under that notion of legal certainty, a notion of equality, that it must be equally applied. So there's a strong notion of equality under the rule of law. Laws are rules of general application, and they must be available to the public and accessible to all and applied to all, and must be in a sense foreseeable. And then the other aspect of the rule of law, of course, is that this isn't quite as obvious always, that the law must be, decisions about your life, let's put it that way, must be able to be challenged if they're made by public officials. And hence the right to a fair trial and an effective remedy. And of course, moving on in our documents here, before an independent court or tribunal, independent and impartial, also part of the rule of law, and within the notion of what is a fair trial. So there are these rules, but they aren't applied arbitrarily. They're applied within the concept generally of legality. They must be made in a way that is clear and certain and predictable, the notion of legal certainty, and they must be able to be challenged through a fair trial before an independent court and provide an effective remedy. So all these things, as I said at the beginning, hang together as part of the general concept of the rule of law. And there are other aspects of it which I won't have time to go into now, but could come up in the questions, namely proportionality, which is very much connected to the lack of arbitrariness. Even when law cannot be applied in a way that is oppressive, it must be done in a way that is measured and reasonably applied. And of course, it applies to, and this is absolutely vital, on the international front as well as the national front. And this is a point that's made here. It was made in the Venice Commission document, and it is made elsewhere, plus a review of constitutionality. So let me stop there. Thank you very much.
Thank you very much. Thank you very much to Elise Muir and to Sir Geoffrey Drowell. I think that's an excellent introduction to a deeper analysis now that we will have with our further wonderful panelists. Sir Geoffrey mentioned the Venice Commission, and so we are very privileged to have with us President of the Venice Commission, Claire Bassi-Mallory. She successively had various public positions, such as Director of Financial Affairs and General Administration at the Ministry of Infrastructure in France. She was also a member of the Commission for the Compensation of Victims of Spoliation resulting from the anti-Semitic legislation in force during the occupation in France. She was also President of the Chamber of the Court of Financial Auditors. And in August 2010, she was appointed as a member of the Constitutional Council of France, where she held also a full 9-year term from 2013. Despite that former position, she will not deal with Principle 13 on review of constitutionality, which I'm sure she could do perfectly, but she will focus on Principle 7 to 9, so rule of law, legality, and legal certainty. Of course, as President of the Venice Commission, you are very well placed to comment on this. I'm looking forward to listen to you. You have the floor, Mrs. President. You're still muted. Yeah, now.
Okay, thank you. Well, thank you very much, ladies and gentlemen. Yes, I'm the president of the Venice Commission, and as such, I probably had not so much to add to what said Sir Joel, but I'll try to make things and our presentation of where is the Venice Commission at the moment, talking and thinking about the rule of law. Well, the Venice Commission, as the body of the Council of Europe in charge of constitutional matters, is really familiar with the constitutional principles of democracy, and in particular with the aspects of the rule of law discussed today. Like does the Charter, the Council of Europe, and in particular the Venice Commission, have also always underlined the close links between the 3 pillars of the Council of Europe. That's democracy, human rights, and the rule of law. This appears in particular in the rule of law checklist adopted by the Venice Commission in 2016, about which Sir Joel was talking. And it was then endorsed by the Committee of Ministers, the Congress, and the Parliamentary Assembly of the Council of Europe. That means the political bodies of the Council of Europe, and supported again by the heads of state and government at last year's Reykjavik summit. A reflection on the constitutive principles of a modern democracy is in progress within the Council of Europe, which at its Reykjavik summit adopted, together with its final declaration, the Reykjavik's Principles for Democracy. That's a set of 10 principles encompassing full, equal, and meaningful democratic participation, free and fair elections, and the related freedoms of association and assembly, and especially freedom of expression, the separation of powers, and the independence of the judiciary, the fight against corruption, democratic participation, support for the role of civil society. I will analyze the work of ELI in the context of the ongoing work of the Council of Europe as a follow-up to the summit. Indeed, the Venice Commission will work in synergy with the newly created Steering Committee for Democracy towards the implementation of the Reykjavik's Principles for Democracy, in particular in the electoral field. The Venice Commission has also undertaken to update the rule of law checklist with the intention to address also the democratic backsliding which we have witnessed in Europe during the last years. My speech will be divided in two parts. First, I will refer in a general manner to the documents of the Venice Commission on the rule of law at a time when the updating of the rule of law checklist is envisaged. And in the second part, I will focus on your three principles, 7 to 9, relating to the rule of law and mentioned in the title of my intervention. The two main documents of the Venice Commission in the field are the report of the rule of law, which was issued in 2011, and the rule of law checklist in 2016. And Sir Geoffrey Joel was one of the rapporteurs of both documents. The report identified the 5 main pillars of the rule of law: legality, legal certainty, prevention of abuse or misuse of powers, equality and non-discrimination, as well as access to justice. But for its part, the rule of law checklist is an evaluation instrument. It contains detailed questions aimed at assessing the degree of respect for the rule of law in any given country, and is addressed, in fact, to all stakeholders: national authorities, international organizations, and civil society. The rule of law can only flourish in a country whose inhabitants are collectively responsible for its implementation, making it an integral part of their own legal, political, and social culture. So the way of addressing the same issue may depend on the country. The factual situation and the social behaviors have to be considered. I know that this has led to criticism about double standards, but lawyers know that equality may mean treating differently what is different. A provision which does not cause any problem in a country can be fairly problematic in another one. While the same requirements apply to all, they may be addressed in different ways in different countries. The Charter doesn't say anything else when stating that the rapporteurs recognize that some of the principles articulated in this Charter should permit variation in accordance with national contexts. The further work of the Council of Europe on the implementation of the Principles for Democracy, and in particular the update of the rule of law checklist, should take account of the constant developments in the field of new technologies and artificial intelligence, as this is the case, for instance, for example, in Principle 32, entitled Automated Decision Making, which could inspire us. The Venice Commission is thus preparing an interpretative declaration of the Code of Good Practice in Electoral Matters concerning the use of digital technology and artificial intelligence in the electoral process. It should also take into account the experience collected in the last year, and you see that in some of our opinions. Let's now come more precisely to the 3 principles which I have been invited to comment more in detail. Principle 7, the rule of law requires public and private power to be exercised in accordance with the law. At first sight, the content of these principles appears as rather narrow compared with the approach of the Venice Commission. However, I do not see a contradiction. First, the Charter makes it clear that the rule of law includes all principles appearing in Part 2 and under the title Rule of Law. A clear reference is made to the Venice Commission report on the rule of law and its content. While in its 2011 report, the Venice Commission had decided not to give a definition of the rule of law, but rather to identify the main aspects which are covered by it, it had found the definition given by Lord Bingham and quoted in the Charter as the most appropriate one. So we are on the same line. In other words, the definition given by Principle 7 should be understood broadly, as made clear by the commentary on the principle, which reminds that a substantive version of the rule of law, which encompasses democracy and the protection of human dignity, is supported by international organizations. It's not a mere expression of the principle of legality. It could, however, be expressly said that human rights and not only human dignity should be included. Principle 8 deals with the principle of legality, underlying that everyone, government and public authorities like private persons, is under the law. This also corresponds to the Council of Europe's and especially the Venice Commission's approach. Respect for the law concerns the whole legal order, including the Constitution and international law. This could perhaps be made clearer in the Charter. Moreover, the law has to be interpreted and applied in conformity with other principles relating to the rule of law, democracy, and human rights, as mentioned inter alia in the commentary for the Principle 7. If respect for these principles is not possible, a revision of the legislation and even of the Constitution should be considered. Principle 8 also insists on the necessity of a transparent, accountable, and democratic process for the adoption of laws. This requirement already appeared in the rule of law checklist, and the ulterior experience showed still better how legislative procedures can be mismanaged in order to avoid thorough reflection and discussion involving all stakeholders. The quality of the legislative process is not a mere procedural matter, but its weaknesses affect the very substance of the law. And the Venice Commission has repeatedly referred to this requirement in its opinions. And that's why the Reykjavik principles have made it clear that transparency and accountability are core democratic values. Principle 8 also mentions the limits to discretion and duty of public authorities to exercise their powers for the purposes for which they are confirmed, while the commentary mentioned the prohibition of arbitrariness. The Venice Commission considers prevention of abuse or misuse of powers as one of the other 5 pillars of the rule of law, a pillar which includes prohibition of arbitrariness and limits to discretionary power. While these concepts repeatedly appear in the Charter, it could be envisaged to address them in 1 or 2 specific principles separately from legality, proportionality, or access to justice. The last principle I have been invited to comment on is Principle 9, legal certainty. The Venice Commission considers it too as one of the 5 pillars of the rule of law. Legal certainty, and more precisely, exactly what have been said before, and more precisely, predictability or foreseeability of law is essential to ensure confidence in the judiciary and, more broadly, in the whole system of governments. Principle 9 and its commentary and the rule of law checklist are on the same line, in particular by mentioning legitimate expectations, non-retroactivity, as well as nullum crimen sine and nulla pena sine lege, and consistency of the law. I think one more concept should be emphasized, stability of law, which is alluded to in the Principle 9. Here again, I refer to the recent experience. Instability of the law has a pernicious effect, making it difficult for individuals to know and apply the law. Unstable legislation appears as the arbitrary choice of those in power. Stability of the law is especially crucial in the electoral field, as already long stated by the Venice Commission and underlined in the follow-up to the Reykjavik Declaration, which refers to future work on the Venice Commission's work in the field. In conclusion, there are big convergences between the ELI and the Council of Europe when approaching the rule of law issue and more generally democratic principles. ELI's contribution will be useful for the future work of the Council of Europe and in particular of the Venice Commission in the follow-up to the Reykjavik Declaration. And thank you very much for your attention.
Thank you very much to you, Claire Brasi-Mallory, for both the, as we would say in German, Ist-Zustand, where we are with the Venice Commission right now, and also, of course, with this very useful comparison of Principles 7, 8, and 9, and the Venice Commission works and principles. That will help us now to get to our next panelist, Gareth Davis. Gareth Davis was a barrister in London before being a university lecturer at the University of Groningen. And then he moved to the Vrije Universiteit Amsterdam, where he is presently teaching. His research focus is on EU constitutional law, EU internal market, and European citizenship. In 2006, he was an Émile Noël Fellow at New York University Law School, and in 2014, a Fernand Braudel Senior Fellow at the EUI. He's a co-author with Damian Chalmers and others of EU Law, which has been published in the 5th edition, I think now, by Cambridge University Press. And he will not speak directly about EU law, but about principles 10 and 11, focus on judicial review of government actions, reflections on proportionality and fair trial. Gareth, you have the floor.
Thank you very much for the introduction and for allowing me to be here and join this seminar. I may mention EU law because proportionality and EU law are quite close bedfellows. It seems to me that as the two introductory speakers both in a way briefly mentioned or implied, there's always a challenge with constructing something like this, a sort of general statement of principles, to find a middle way between meaningless and over-constraint. On the one hand, there's a risk that one comes with something so general and banal that you think, well, you know, what's the contribution? On the other hand, you can come with something more concrete, and then someone will complain that it's actually really quite an uncomfortable fit for their legitimate traditions. Which is not to say it's not worth trying to find that middle way, it's just that that's the challenge. It does also raise the question, for me at least, of what one achieves with this. I do think that sometimes creating a common text and agreeing to fly under the flag of a common principle can be unifying. In the sense I've argued this in the context of EU law. We may have different ways of running our governments and our legal systems, but if we agree on certain principles, then it enables diverse systems to participate in a common conversation, and it makes it easier for them to learn from each other as well, and perhaps move towards each other, and it can have this constructive effect, and that's certainly to be hoped. But it can also, I think, work the other way around, in that it can also be divisive. The way governments and legal systems work is very much a product of history and of culture and quite possibly even the weather, if one believes some of the popular books about how states are formed and so on. And if we put this in the context of common principles, there is a risk that one translates differences and diversity into constitutional disagreements, that one makes things sharper than needs to be. So again, that's not a reason not to do it. It's just that this is always going to be a surprisingly dangerous exercise and surprisingly difficult one to get perfect. And I suppose that's the case for anything interesting or worthwhile. The two articles that I was asked to comment on, it seems to me to some extent capture both extremes of the problem. And one of them is the principle of fair trial, where I think perhaps the risk is that it becomes over generic. And the other one is the principle of proportionality, where I think perhaps the risk is that it can become over-specific. So let me say a few words about those two. Fair trial, what I find interesting about fair trial as a general principle is I think it might be the case that probably every country on the planet would agree to this. I'm not entirely sure. It may be that there are a few ex-communist countries that do actually reject, as a matter of principle, the individualism inherent in the idea of defending oneself and asserting individual rights. But I could imagine there are countries that we might not consider as having fair trial in practice, but they would nevertheless sign up to this. There should be a legal system which allows people to appropriately assert the rights that the law gives them. And that's when one sees that it's very, very non-constraining, to the point perhaps of being banal. And even within Europe, and within within the world of liberal democracies, there are quite radical differences in what is considered to be fair, if I can make that one word do all the work. And one can think here of juries, of course, but also on rules of evidence and on the role of the judge in course. And these are not just accidental things. They can reflect quite principled understandings about the relationship between individuals and their state, and between citizens, each other, and privacy, for example, in the case of evidence things. We don't all have the same conception of what fair is. So it does to me raise the question of what is this doing, and what is how much work can this word fair really do for us, and how much can it achieve, or is it just indeed a locus for putting all our disagreements next to each other? Ironically, it seems to me that probably the aspect of Article 10, I think it is, which perhaps is most uniting, where in concreto, I think almost everyone probably agrees, is Article 10.4, the principle of legal aid. Because as far as I'm aware, there is no country on the planet that makes any serious attempt to comply with this at all. It speaks of providing legal aid such as to ensure effective access to justice. Possibly in criminal cases, one could say one comes quite close to this. Universal, and certainly it's the case that in the Netherlands and Britain, the two countries where I may know a little bit about, how much money you have very much determines the quality of your representation, and it really determines very much your ability to assert your rights and the chance that you will successfully do so, and the ability to defend your rights. And it is not the case that everyone gets legal aid in the case of a civil dispute or a civil, such that they are put in the position equal to the strongest and richest litigant. You know, justice is to some extent according to means, and governments actually use this quite consciously. They cut legal aid in order to discourage people from suing too much, because they don't like having too many lawsuits about things they don't consider very important. And even governments that don't admit that they're doing this, in practice they do. And I don't say this from some sort of radical revolutionary point of view that means we have the world is not perfect and will not be perfect. And within the context of liberal capitalism, I think it's unlikely that we can develop a legal system which entirely removes inequalities. But then I find it interesting to claim as a shared proposition that we are really trying to do that, because it seems to me any meaningful, effective access to a justice does imply some kind of equal access. So I mean, descriptively, I don't think it's probably true. One could put it in there aspirationally and say, no, well, I mean, it's, you know, nothing's perfect. No right is achieved perfectly as an aspiration. But I'm actually not totally convinced that this is an aspiration of any liberal democracy, in the sense that I am not convinced that any government seriously is attempting to make the policy that would ensure that all citizens have equal access to civil justice. Maybe Article 10.4 should say something politically adequate access to justice, or sufficient access to justice. It's just that it's an imperfect world, but it does raise the question of to what extent it's cheating to proclaim aspirations to utopia if we're not really taking steps to achieve them. Proportionality, on the other hand, is interesting. I mean, I think, again, something that everybody does probably agree on within liberal democracies is the idea that there should be some kind of accountability by all levels of government, whether it is in fact the legislature or the administration, that to some extent they must be subject to the law. There has to be some kind of review. So I think I could get a pretty high sign up to a proposition like that. But styles of review are very, very different from the sort of Danish extremely procedural one, which essentially takes the view, and it used to be the British one as well. I think Britain is now much more complicated than it was when I was at briefly studied law. But where it's essentially, if the procedure's followed, then the judge doesn't really have very much to say about it, through to countries that have and the EU, which have an extremely intrusive tradition of essentially second guessing the legislature and deciding whether they think policies are really important enough to be allowed to go ahead, which is what the Court of Justice does. You know, it makes a balance and so on. So there's a very, very wide range, and they all have something to be said for them. And probably one could ask the question of which is best, but I'm not sure whether those kinds of questions tend to be hugely constructive. It's probably more a question of which one suits which context. And I think, you know, Denmark does have a tradition of judicial review, which often from the outside invites the criticisms that they don't really have the rule of law and their government's not accountable. On the other hand, it is in the context of an extremely high functioning and law-abiding state. So maybe one should not leap to that conclusion terribly fast. So it's probably a question that different styles of review do suit different contexts and histories and people. And what seems to me distinctive about proportionality is that it's not a neutral umbrella term which just encompasses the idea of review. It's distinctively substantive and intrusive. And I think most countries have a much more marginal and procedural approach to judicial review than is implied in proportionality. Proportionality does imply a sort of judicial engagement with substance. I think it actually implies a kind of evidence-based law as well, in its three formal stages of effectiveness, necessity, and even balancing, if one thinks that's part of the law. It does imply a sort of an evidence-based approach. And evidence-based law is one of those things that when you say it, it always sounds very sensible. Who's going to be against it? But it does forget that law is the process of politics, and politics is the result of politics, and politics is the result of, you know, the joke about sausages and law, emotions and histories and traditions and identities and things which are not terribly subject, not amenable to evidential review. So I think proportionality is quite a controversial choice. I mean, my last 2 minutes, if I have them, it comes, of course, if proportionality is spreading and is becoming the de facto language of review, which I think probably is empirically correct, that it is spreading, even though I'm not sure it's being used, that's thanks to the European Union. And the European Union does a very different kind of judicial review from any other state, because it largely engages with conflicts between democratic laws, those made at the national level and those made at the EU level. And this is an extremely problematic situation where there is no neutral role for a court, frankly. You can't avoid taking sides. That's quite different from judicial review at a national level, which is typically the individual against the democratic legislature, and where a more marginal and procedural approach is on the whole justified. So I think taking concepts from the EU, which often took them from German constitutional law, even though in German constitutional law, like subsidiarity, they often don't work very well. So there's a rather dysfunctional path in the way that our principles sometimes go in Europe. The Germans give them to Europe, Europe sort of misuses them, and then everyone else copies them. But there certainly are very mixed results at the European Union level. I mean, I'm in some ways quite a fan of the Court of Justice, which has done many very good things for Europe, and often faces unjustified criticism from people who don't understand its context. But there's no doubt that in its attempt to turn, it does engage in very intrusive review, and there is quite a political backlash against it. And I don't think the court is over on whether it should be more so intrusive or whether it should back off. And even it doesn't really apply a proportionality in any consistent sense. It generally misses off the third element, and it implies the first two elements in fairly arbitrary ways, sometimes wanting evidence and sometimes not wanting evidence. So again, proportionality is the label, but whether it actually lives up to that label, I'm not sure. And it does have rather mixed results. I mean, as a final 30 seconds, I think the thing about proportionality is it's all about judicial empowerment. If you choose that for your label for review, you are making a choice to empower judges. To some extent, it's an economic efficiency principle because of its emphasis on evidence, and its emphasis on, do you have a sufficient reason for this? Can you show it's necessary? And it's all part of the process of depoliticization of law, I think, of trying to reduce it to a technical exercise. And there is something to be said for all those processes, certainly by contrast with the alternative of wildly inefficient, spontaneous, emotion-driven and utterly unevidence-based law. But I'm not sure that either extreme is really politically stable. So I think proportionality is an interesting principle, but quite a controversial one. And on the whole, I'm not totally comfortable with universalizing. I think I'd rather see a diversity of judicial review approaches, and we can let them fight it out over time and see if we converge or not. Thank you very much.
Thank you very much, Gareth, for these very astute reflections, which were not over generic and not over specific as well. I think it was really interesting, and I think you put also into the discussion the whole issue about principles towards legal realism and where one has to sit in order to make that job. And when I'm speaking about legal realism, of course, I think about the US, and that's a lead to our next panelist, Kimlane Shepley. She is Lawrence Rockefeller Professor of Sociology and International Affairs at Princeton University, where she teaches EU law and comparative constitutional law. And for that more than a decade, she has written about challenges to rule of law principles by rogue EU member states. And her forthcoming book, Destroying Democracy by Law, will be published by Harvard University Press. And I'd like to thank you very much also for raising up early to be with us. I wanted to say this morning or this afternoon for us. Kimlane, you have the floor.
Thank you so much. And I'm sorry for joining the webinar almost a little bit late, because it's not just that it's earlier here, it's that we've switched to daylight savings time, but you haven't. So my usual calculations about the time difference were almost destroyed my participation in all of this. Anyway, so first of all, I'm really honored to be part of this, both to be part of the discussions of these fundamental principles as they were going together, and now to be part of the webinar that discusses them. And you know, as prior speakers have said, this is a very dangerous exercise to engage in, because principles without a context and without a factual basis, you know, run the risk of either being platitudes or making it sound like all states have to fit some narrow one-size-fits-all set of principles. So I agree with what Gareth Davies just said about this. I think it's a complicated exercise. But I think it's also important to remember the moment that we're in and why this kind of exercise is useful and necessary. So for the last 20 years or so, all of the agencies that monitor the health of democracy, human rights, and the rule of law have been noticing that all of these principles, the adherence to all of these principles, have been declining, and declining quite radically across the board. So not just in fragile or new democracies that may never have completely fully integrated these principles, but even in states that think of themselves as really upholding, perhaps even having invented a lot of these principles. So even in solid democracies, I speak to you from the US, where we're all in a panic about what's going to happen in the next election, and where we've had elections that have misfired, and you know, aspirational autocrats at the helm of our own government. This is happening across the world. And so it matters now that we sort of, those of us who have defended constitutional democracy, try to get together and think about what it is that we're defending. And this kind of defense has a couple of important points, I think. One is that I think most of us, and you know, the world at large, I think, has been very slow to recognize just how profound this backsliding democracy phenomenon is, precisely because there's such variation in the way that constitutional democracies function. It's very easy to assume that some variation in the way one country is doing something is part of the normal, if I may borrow a concept from the Court of Human Rights, normal margin of appreciation that countries have when they engage in the practices of constitutional democracy. So variation is an important aspect of this concept, and yet it's very often exactly that variation that countries hide behind when they're engaged in backsliding. So, for example, one of the things I think we see now is that it used to be quite obvious when a democracy would collapse. There would be tanks in the streets, the military would be called out, the law would be suspended, and you'd have all of the features of a kind of garden variety coup. But these days, governments don't fall by coup very often. They fall instead when an aspirational autocrat is elected in a free and fair election and then proceeds to dismantle the constitutional democracy that he inherited and to do it by law. Very often laws that copy the laws of good democracies, but that in the context in which they're now deployed, produce really disastrous consequences. So this is why I think this is the context within which an exercise like this, where we think about, well, what's the point of the activity? So not what are the specific rules, not to get into, you must do it this way or that way, but what are the general principles that constitutional democracy should aim at? This becomes an incredibly important exercise precisely when these principles are really under threat, and when they're under threat, particularly by aspirational autocrats who pretend to stand for those principles. So again, I think that's the context within which this exercise occurs. And that's why I'm particularly happy to be invited to comment on two of the principles in this rule of law chapter. One is Principle 12, which is respect for international law. And the other is Principle 13, which is the review of constitutionality. So why am I particularly excited about those two? Well, I think one of the things we've seen, and this is particularly true, and again, this is principles of European constitutional democracy. So I might say the US might very differ from a lot of these, which is precisely why I teach mostly European law and not US law, actually here in the US. But respect for international law is something that I think can give us a kind of North Star, something that we can orient ourselves around in thinking about how European democracies function. And so let me read just Principle 12, Part 1, says that a state must abide by its international commitments and respect the principles of international law. And Part 2 says, in their international relations, states shall be guided by the values of liberal democracy as defined in Principle 1 of these fundamental principles, which was the subject of the last webinar. So why does that matter? So within Europe, almost all European countries, we can exempt, I suppose, Belarus, but all the other European countries have signed on to either or both of the Council of Europe principles, including the European Convention, and also many states have signed on to the principles of EU law. And those two sets of principles, which should be mutually complementary, although we're in a moment when we can think that they're not always mutually complementary, those two sets of principles matter because they underwrite and they support national constitutional democracy. And so as a result, when you start to see countries that begin to violate the principles, either of the Council of Europe or of the EU, then one of the things that tells you is that they really are pulling away from the European consensus about what constitutional democracy involves. In some of my writings on this subject, I've called this adherence to international law as part of constitutionalism, what I call the rule of law writ large. If you think of the rule of law writ small as all of the analyses that all of us have read, I teach a course on rule of law, and there's this obsession about coherence and predictability and non-contradiction, as if the only thing you care about is what happens within a constitutional bubble of one state. And what that means is that you get an autocrat that comes to power, can move the entire state in one direction that is away from the kinds of principles this charter is designed to defend. Autocrat moves them away while still adhering to non-contradiction, predictability, what we call government by law. So the question is how you know. What's the early warning signal that tells you that that's what's happening inside a state? And a lot of it is that the country is moving away from its moorings in international law, and particularly in European law. So the rule of law writ large, I argue, is what happens if you think of the rule of law not just in a national bubble, but as trying to achieve coherence across all of the principles that a state has signed on to, whether they're domestic or transnational. So basically, this means, first of all, that states should honor their commitments. And it also means that, if a state has strayed from these principles, and we now have some even EU member states that have strayed rather far from these principles, what it tells you is that if a new government is elected, and actually has to even break some national legal rules in order to comply with transnational law. They're not doing some rogue activity. They're actually trying to achieve the rule of law writ large by bringing their national system into some coherent relationship with the transnational commitments they've made. In other words, one way to think about this respect for international law is precisely that it acts as a kind of North Star outside the current legal system that you're looking at to figure out which direction it's actually moving in, toward or away from constitutional democracy. So this is one of the other aspects of respect for international law that I think has an important place to play in our particular present moment. Now, and I think it's somewhat more controversial that this principle builds in that states should be guided by liberal democracy and by the principles of liberal democracy. But since in many ways that was the inspiration for doing these principles in the first place, what does it mean to take note of the common constitutional traditions of the states of Europe? That's very much where they start, and that's very much what these principles hold them to. So that's the principle of international law. Now, principle 13 is the review of constitutionality. And what I want to argue here is actually that this is a good package with principle 12. So what is principle 13? So just to read it, it says, courts must have the jurisdiction to examine the compatibility of state measures, including legislative acts, with the fundamental constitutional principles. Okay, now I know the committee debated a lot on whether to say courts or whether there has to be some institution. But I think it's important to say, I think, courts here, in part because you need a domestic system for understanding how to assess lower norms against the higher norms of a system. And the way most countries do that is through courts. There are other mechanisms that can be used, ombudsmen, human rights committees, and so on. But I think, you know, as constitutional systems evolve, courts have become the primary mechanism for doing this. But the crucial thing, I think, is that some independent authority must assess whether the state is following the principles entrenched in its own constitution. And you see how important courts are, because it's very often the case that the first target of aspirational autocrats is the constitutional court or the body that performs that function. So if I'm writing a book on this, I can tell you even outside of Europe, the first danger signal is court packing, or trying to neutralize the body that can tell an aspirational autocrat that what he's doing violates the basic principles of the government that he started with. So the fact that this is so often a target tells you it's also very powerful and very important. It's also the case that the attack on the constitutional monitor is also one of the important first signs that tells you when a government is in trouble. So I read these principles as providing not just a useful checklist to assess, you know, a state in a kind of steady state, so to speak, but also to tell you when a change, because, you know, what is a democratic system for but to have an election and then the elected officials change the law? That's how it's supposed to work. So how do you know when these changes in law are really leading you into a dangerous path? And the answer is, if one of the first things the aspirational autocrat does is to attack the constitutional monitor, that's a sign of trouble, right? So this is yet another kind of early warning signal. And this is where I want to link, you know, in a kind of concluding comment here, Principle 13 with Principle 12. And this builds a bit off what Gareth Davies said earlier. If you live in Europe, you live in a web of courts that are both national and transnational. And one of the things that these transnational courts do, and have been increasingly doing, actually, I mean, I think 10 years ago, when I think I wrote my first article on the legal enforceability of Article 2, and everybody just assumed I didn't know a thing about EU law, we're now actually in a world in which the Court of Justice not only is enforcing the values of Article 2, rule of law in particular, but is actually giving signals that they would rather enforce more of these principles as well. So this has been a consequence of living in a world of backsliding states, where the Court of Justice has really been on fire about this issue. And also the Court of Human Rights has also been adjusting its jurisprudence so that it's not just, not that it ever quite was, but it's not mostly a court that is assessing individual rights against a state, but is also building the family of individual rights into requirements of state structure, so that the right to a fair trial becomes the requirement of judicial independence. The right to free elections becomes a kind of claim on the neutrality of election administration. We're seeing both of these courts begin to develop not just a jurisprudence of individual rights and not just a jurisprudence of their own particular legal documents, but they're starting to now require a more fulsome institutional manifestation of the principles of constitutional democracy. And so this is where I want to say, following international law, as Principle 12 requires, and having a review of constitutionality, as Principle 13 requires, are increasingly in Europe the same thing, which is to say that transnational courts have been rising to the challenge of becoming a backstop for when the constitutional courts or the constitutional review of the member states fails, precisely because it has been captured. So I think that these two principles should be seen as part of a web. In fact, the whole point of this exercise is to develop a web of constitutional principles stated with enough generality so that there can be variation in how they're achieved, but with enough firmness that you know when a member state has departed from them. And I'm afraid that that's the world in which we live. Hence, it's the world in which we need these principles. Thank you so much.
Thank you very much, Kim-Lynn Shipley, for this. For these comments. I had the impression you also try to show the coherence, which is almost an underlying principle between 12 and 13, which is really very interesting, and putting in the center, of course, EU and EU law leads me quite naturally to our next and last but not least speaker today, Florian Geyer. Florian Geyer is a lawyer and has been working for the European Commission for more than 15 years in various directorates general. And before joining the Commission, he was a research fellow at the Center for European Policy Studies in Brussels and a senior research assistant in public law at the University of Trier in Germany. Since June 21, he's the head of unit responsible for rule of law in the DJ for Justice and Consumers of the European Commission. And therefore, he has been asked to give us his reflections on the so-called timeliness of the report and how part 2 of the same can support the work of the EU Commission and broader efforts in that field. I'm very pleased to hand over to you, Florian.
Yes, thank you. Thank you so much, and hello to everyone. If you allow, we are running a bit out of time, so I try maybe to condense even more what I had planned to say so that we have time for questions. And I will briefly come to the timeliness in a moment, but let me just, if you allow, link back to what also Professor Scheperle has said just now about the web of courts in the EU, the margin of discretion and the two principles that were discussed before. And there, I would like to pinpoint also look at one of the points that were made in the report in principle 7 on the rule of law, when it's written on page 34, that the Court of Justice, and this is what we were discussing before, also the respect for the supranational legal orders and the international legal order, has used the principle of the rule of law in Article 19 to impose obligation on the member states regarding their system of governance, including or especially judicial independence. And here, I think, if you'll allow me to give a bit of a twist to the notion of impose an obligation, and come back to what the Court of Justice also said in the rulings on the conditionality regulation, which is one of the key innovative features in the EU legal order, where in relation to the margin of discretion at the national identities, and we all know the jurisprudence of national constitutional courts relying on national identities to evade maybe an obligation from EU law, where the Court of Justice made clear to say that the rule of law, Article 2, and everything that is enshrined in it has become part of of each member state's own national identity. And there is no way to use a concept of national constitutional identity to evade the core tenets of what the EU rule of law concept entails, and that every member state that voluntarily joined the union knew what they were signing up to when they joined. And it's not just at the moment of accession that you have to a tick boxing exercise that you comply with the rule of law and then you can do whatever you want afterwards. I think this key component, that is not an obligation that is foreign, that is outside of the national constitutional system, but the fact that it's inherent in each EU member state who voluntarily joins, I think is a very important obligation. And that then links also, of course, to the timeliness point. I think the rule of law at the European Union level has never been debated as much as it has been over the last couple of years. I think we see that not only, you know, in the work that all the distinguished panelists and many more in the academic world have been showing, but also as a reality on the ground. The fact that it has become such an important topic at EU level has been driven also by simple de facto the realities that we have seen, the political developments that we have seen in the ground. The different actors at the EU level have increased their own capacity to deal with rule of law issues. The European Parliament, on the one hand, has always been, you know, a very strong driver on these matters and had for a long time developed its capacities, but also the Council of the Member States, the Council of the EU, after having an initial rule of law dialogue, which was more like an aleatoric thematic discussion once a year on some topics that had nothing to do with the realities that were actually happening, into, since 2019 and 20, into a more structured way of bringing the member states and the ministers together to discuss horizontal issues, but at the same time, country-specific discussions, member state by member state, on equal footing, in a peer discussion, in a regular return, in a regular coming back to those issues. This has been, I think, a major shift also on the side of the Council. This process, this dialogue was evaluated at the end of last year, 2023, by the Spanish presidency, and it was agreed that this is a better way to go forward than the very old 2014 concept of this isolated thematic debates, although some of the member states tried to turn back time, to claw back to this very, you know, like neutral and toothless way of discussing the rule of law, but they failed in convincing the other member states to return and turn back this time. Now, at the Commission side, and as I said, I don't want to go too deep, too long, because you know all the principles, of course, but in fact, rule of law before, 10 years ago was discussed in the enlargement context. When we discussed Copenhagen criteria, when new member states needed to fulfill certain requirements, and once they were in, everything was taken for granted. All the respect for the Article 2 values were taken for granted, and the only safeguard was Article 7, that existed in the treaty, but was a very, far away and not really activated concept. And the first time that this transition between the enlargement and the outside and the inside converged was with the cooperation and verification mechanism for Bulgaria and Romania, where it was said, okay, actually, we want Bulgaria and Romania to be part of the Union for political reasons, although we know from a rule of law perspective, judicial independence, anti-corruption, they might not have been where they should be at the time of accession. So this cooperation verification mechanism was created, and that was the first bridge to the inside from the outside. And it lasted for 15 years and was only concluded at the end of September, mid-September last year. And it was created also because everything has changed inside the Union. The understanding, the tools, the mechanisms have changed. Whereas before there was just Article 7, now, within the last couple of years, starting from, of course, the tools, which were mainly an inception, a seedling, like the Justice Scoreboard, comparing the justice systems in the member states, moving to the pre-Article 7 rule of law framework of 2014, then bringing this question of anti-corruption, rule of law, efficiency of justice, but also lawmaking and legislative procedures, emergency ordinances into the semester process, which is the tool for the economic governance, but with a strong link to the investment protection, has become a first driver. And then I think in the last decade, in the last mandate in particular, with the entirely new tools like the conditionality regulation, the horizontal enabling conditions, which is something that is very often overlooked. It's the Charter Horizontal Enabling Conditions for Cohesion Funds, which has become a very important tool in the wider, drive to respect, to make everyone respect fundamental rights, and amongst others also Article 47, the right to an effective judicial remedy. Then the positive incentive through the Recovery and Resilience Facility, where lots of milestones directly relate to the judicial system, to anti-corruption, to lawmaking efforts. Plus combined, and this is, I think, the major shift also in the way of looking at things, the rule of law report, where we try for all 27 member states to come year on year with developments as a basis for discussion, not as a means in itself. I think this is very important. That also us here as the unit in charge of leading this process on the rule of law report, we are not looking at this rule of law report as a means in itself, but as a basis for further action, as a basis for dialogue in the Council, in member states, in Parliament, in our own negotiations with the member states, in trying to address the issues, address the recommendations that we try to come forward with in the rule of law report. And that is something that has simply shifted the narrative away from the previous time when it was only discussed when there was a crisis and then too late. Now with the rule of law report, we want to be ahead of the next crisis and also outside of the crisis, because rule of law matters and rule of law issues are not only crisis issues. When they have become a crisis issue, it's too late. So the rule of law report tries to work ahead of this. And we hope that we have contributed to making this a more standard, a discussion that we can have with member states outside of a framework of crisis and then political accusations and political blaming, which it very quickly draws into here at the European Union level, as you can imagine. Is it timeliness, the charter that you do? Of course, it's amazingly timely. We are at the verge again of a cycle where European Parliament elections will be taking place. A new leadership will be coming to the Commission. A new leadership will occupy all the institutions at the European Union level. And the question how we will continue the work on the rule of law is a crucial one. Will we continue at a steady pace as we did so far? Will we increase the activities, or will the new leadership say we have had enough of rule of law at EU level? It's a distraction, it's a nuisance. It's not leading to the results that we had been hoping for, and it's sowing divisions between member states, because what we want to achieve are different issues than making member states adhere to Article 2 and the values. These are nice things to have, but we have the economy, we have a war, and we have other things on the plate. So the Charter, I think, is a fundamentally important contribution to this debate in, again, operationalizing it, bringing it on an equal footing, and contributing in a very, very valuable way. You will see our rule of law report is differently organized than the Charter, but that doesn't matter. That's just a presentational issue. I think it goes throughout. We have 4 pillars. You have a different way of structuring it, but the content that lies behind is the issue that matters. And on that, we are very grateful for the work that was done, and we will certainly use that in the future. Thank you very much.
Thank you very much, Florian Geyer, for this assessment as well. And we only have a couple of minutes for questions, but so I don't want to interfere too much with the questions we have. So maybe I will begin with the first one to Sir Geoffrey Joel, because there's an interesting question about the precondition on public and political discourse as an unwritten precondition of the rule of law. And the question was, how far do you think this might engender the rule of law, and also to what extent that discourse may play a role, and underlying, of course, the whole education to the rule of law is also popping up. So I thought maybe I would ask you your initial thoughts, and maybe we will go on with a further one. So Geoffrey Joel, if you want to answer that question, otherwise you can pass. But
very kind of you to ask me, because as I said, I have to leave in a couple of minutes, for which
That's
I
why.
do apologize.
Yeah.
Well, I think that what has been said, I find what has been said has been very valuable. First of all, I've enjoyed all the papers except my own. But I've learned from them all very much. The person I take most issue with, although I think he was very stimulating, was Gareth Davies, to the extent that I do think that the notion of a fair trial is an aspiration. I've just dug out this book over here that I've been looking at, The Right to a Fair Trial in International Law. It's a very thick book. There's so much to consider in this. Obviously, there will be differences in the notion of a trial in different countries. Chair, I'm not answering your question, but I'm making a more general point. But nevertheless, it's an aspiration. And also, as somebody mentioned, the President, Basie Mallory, said, it's a lodestar, and we aspire to that. And in times of stress, when some countries, and here is the answer to your question, when they seek through political and other ways to depart from the rule of law, it's there, as any Bill of Rights is in a sense, but written in a completely different way as a set of principles. Similarly, proportionality, look at it carefully. It's a way to structure and to constrain discretionary power. It requires that it not interfere excessively. It does bring the courts into substantive decisions. But if you are involved in discretionary powers, which is most of public law, this is a way of doing so. So I stand by the principles. Feel privileged to have been very much involved in them, and but I realize, of course, there are difficulties, there are differences, but nevertheless, I think by having them set out in this way, on the understanding that there'll be some divergences, but at some point you have to be able to say, and this is the task of the Venice Commission, of the EU, and so on. Of course, there are divergences. But at one point, there is a sine qua non. Fine, you can do that, but don't call yourself a liberal democracy and don't pretend to adhere to the rule of law.
Thank you very much for this very affirmative reaction and statement. I find further questions, and there was one for President Basie Mallory, a very long question, but the author says several people spoke about the democratic backsliding, and one issue was what are the causes? Is it the sometimes authoritarian management of COVID, sometimes, of course, the war, sometimes the flows of immigrants that stresses the systems of some European states, and therefore there's no direct question at the end, but therefore I wonder whether the question is, can we with principles do something on that, or are these very practical needs and effective aspects just colliding with a more principled oriented understanding of the rule of law? Not an easy question, but you are still muted, maybe because of my question.
That's not an easy question, and I think if we knew the answer, I will be staying in home, not talking with you, probably. Well, you know, the problem is that democracy is something very complex, and something which is very theoretical for many people. We live in very, I'm sorry, I'm going to make things, you know, so very simple and probably too simple, but I think we live in very complex societies. The building of our societies, especially in Europe, the building of the peace, the building of the European Union and things like, always was tied with pledges for progress, for growth, especially economic and growth, and a better future. And at the moment, for many other reasons, people do think that those pledges are not met, that they are not implemented. And the problem of democracy is that probably the fact that complexity has to be managed, and for citizens, the complexity first, and then the time which requests the implementation of all pledges and hopes and things like that is too long. So how? Well, if there is somebody, the problem is if there is somebody who can answer very simply to a question, well, why not? And why can we participate? But well, I mean, there's no criticism in what I'm saying. It's just the fact. And why are you always waiting and expecting our answers, even if the answers are in the bulletin that you put for the vote? I mean, I can understand that. And when you put that on an extensive view of social media, where all solutions do appear as being possible, well, what will be, how can we make a choice? So you put your confidence in someone, something, and you go on that way. I mean, it's very, I don't think really it is, it's a whole thing. We're talking, when we're talking about backsliding, what are we looking at first at the moment, especially in the Venice Commission? First, access to justice. That doesn't mean that people have difficulties to access to a judge. Is that it's all about independence, independence and impartiality. That means to the choice of justice, of judges, and so on. And the other thing is freedom of expression. So those are two sort of landmarks, because you have to talk to people. How can they have any hope in the implementation, even if we stick to the pledges, political pledges? And the other thing is, how can I choose the best solution? Well, the answer is, well, democracy, you leave that to those who know what it is, and those who bring us a solution, not the solution we can bring. And well, that's very simple, very simple words, very, very difficult question. I mean, it's a whole complex, and that's why rule of law, checklists, and things like that are very important for the authorities.
Thank you very much. I see the timing, of course, and we are getting to an end of this webinar already. And I know that all the panelists would like to intervene on many aspects that were raised by the others, which is the reason why maybe we are a bit late, because the content of your presentations were so rich and interesting that I did not dare to cut you short, because we wanted to hear what you had to say. But I think maybe I could give the last words to the co-reporter, to Elise Muir, and maybe then I'll just say two words. Elise, maybe you want to react on what we've heard right now, and if you read the questions, you may also say something, but you have just 1.5 minutes to answer these questions.
Thank you so much for giving me the floor back, and thank you so much to everyone, participants, were speakers, and members of the audience for comments and questions. I was very, very pleased to hear from Ms. Bassi-Mallory that there is overall an alignment. That's clearly certainly was our idea to, if possible, help further, but certainly not question in any way the work of the Venice Commission. So it's wonderful to hear there are these bridges between our projects. I was also very interested to hear both from Professor Schepele and from Mr. Geyer that there is so much complementarity between the work of the Council of Europe, that of the EU, and initiatives such as this charter through the role of courts, but also political institutions, the Commission, the Council in the EU, the Parliamentary Assembly of the Council of Europe, as we also heard from Ms. Bassi-Mallory. I heard the comments and the thoughts of Professor Davis, but Sir Jeffrey Joe was already reacted, so I will not come back to this. There were a couple of questions that I want to pick up on very briefly. One related to the sort of the precondition for the rule of law that was just being discussed. In the charter, what we did was to be very light touch. I mean, we cannot answer all these difficult questions. This has just been explained, but we did pay attention to the role of education, to the responsibilities of private entities, platforms in the digital sphere, social media, and the need to combat disinformation. So although we do not tackle these preconditions for the rule of law as such, we did pay attention to the threats that may come from certain lack of education or the role of certain private actors. And that is also related to another question that was online, that was in the chat. What attention do we pay for private actors? Well, quite a lot, actually, because we believe that the rule of law is also addressed to private actors. We refer to non-state actors in terms of check and balances, separation of powers, institutional balance, as well as in terms of having to comply with fundamental rights. So these are concerns we have tried to address in the charter, but I don't want to exceed my time, and I'm very happy to give you the very last words, Ms. Professor Pichonaz. Thank you so much again for this opportunity to present our work.
Thank you very much, Professor Muir, for these, also for touching on some of the questions we couldn't ask in more depth. I want to thank all the panelists. I have to say it was really thrilling to listen to all your comments and reflections. And I think it gave some flesh also to the charter in a way. We have now these written comments. We will have a kind of oral webinars that will also be a good way to better understand the rule of law in general, but in particular with this panel also, I think your insights were very useful, and we would love to continue to speak for another 2 hours without difficulties, of course. I'd just like to remind everyone also that we will have the next webinar on judicial independence, and that will also be a big topic on April the 8th from 12:30 to 2 o'clock continental European time. And let me thank you all for being a wonderful panelist today, for attending this webinar. Thank you very much, and I look forward to meet you again online or in person at some point. I wish you a wonderful day. Thank you very much.